White & Case is pleased to bring you this webinar with information on national security reviews. You will hear from two of our partners today, offering an international perspective on trends, recent developments, and best practices. Tobias Heinrich is a partner in White & Case's Frankfurt office and heads the German tech M&A practice. He has more than 12 years of experience advising clients on cross-border M&A and capital markets matters. Tobias has brought experience in international security reviews, including procedures before CFIUS and the White House, as well as the German Federal Ministry for Economic Affairs and Energy. He's a regular speaker at conferences and has authored publications in legal journals and law commentaries. Farhad Jalinous is a partner in our Washington, D.C. office and heads the firm's national security and CFIUS practice. His experience over the last 25 years as a CFIUS practitioner includes negotiating some of the most complex and sensitive national security agreements approved by the U.S. government. Farhad is consistently recognized by Chambers Global as one of the top-tier CFIUS practitioners in the U.S. legal market and is often quoted in prominent publications, including the Wall Street Journal and the Financial Times. We'll hear from Tobias in just a few minutes, but for now, let me turn things over to Farhad to get us into our subject. Over to you, sir.
All right, thank you very much. Good afternoon. It is a pleasure to be here and to present CFIUS or CFIUS, the Committee on Foreign Investment in the United States, from my perspective, and also some general trends and observations from Tobias on foreign direct investment reviews and the protectionism at large. I hope that you enjoy this presentation. It's going to be very much up to date, and it's going to be hopefully giving you some helpful insights into the broad FDI review process. As a preliminary matter, I would like to just point out to you that we here at White & Case have developed what we call a global national security practice. And what this really means is that we have identified capabilities within our offices around the globe who are knowledgeable and ready to engage on advising and assisting clients in foreign direct investment review procedures and processes within their respective jurisdictions. This is something that is relatively new, but it is something that is a trend that we believe is going to be quite important on a going forward basis for cross-border multinational transactions. So with that, maybe Tobias, you can start us off.
Thanks very much from my side as well. And I think we should get right into the substance with our first slide, which we call the graveyard slide, which has a bit of a provocative title, as you can see. Some others have called it the wake-up slide. It really displays transactions over the last 2 years which have either been abandoned or blocked. There was one blocking decision, and we'll come to that in a second. What you can see from these and from the headlines is that we have a variety of repeating patterns and issues. For example, you will identify that there are a couple of PRC bidders actually on that slide which were blocked and which, before the CFIUS regime and supervision, appear to be very vulnerable. There are also industries which are vulnerable, in particular the tech industry, and as a sub-industry to that, the semiconductor industry, where we've seen, especially over the last 1.5 years, that CFIUS took a very strong stance on safeguarding national security in the US. And what you will also see that most of the transactions were actually not blocked, but were abandoned by the parties, which then walked away from the deal or had to walk away from the deal based on the feedback they received from and the indications they received from CFIUS going along the process. There was one deal which we advised on the target side, which was the Extron transaction, which is a German target company which was exposed and subject to a public tender offer in Germany and the US by a Chinese bidder. And again, that transaction went before CFIUS as well. The parties decided, after CFIUS did not recommend the transaction to go through, to put the matter before the White House and get further guidance as to the White House's view on its jurisdictional reach. So with that in mind, we can turn to some data points which we will just like to keep as background, and we can skip this slide actually in order to go to the data points directly, Ken.
Actually, Tobias, let me intercede for 1 second to make one point that I think that is important to keep in mind. The graveyard slide that you just saw, Tobias and I were talking about this presentation yesterday, and we were commenting how, regrettably, that is not a closed graveyard, that there is an anticipation that there are going to be other transactions that are going to be added into the list of transactions that were either abandoned by the parties because of recommendations by the committee, or whether they're going to, for whatever reasons are going to be motivated to take the case or the matter before the president for an ultimate decision. But it is important to keep in mind that, as ominous as that slide may seem, the vast majority of cases that appear before CFIUS are approved. A great vast majority of them are approved, and in fact, a great vast majority of them are approved without any mitigation or conditions. The percentage of cases that are now getting approved with mitigation, that is in fact going up, but nevertheless, it does remain a clear minority of cases that appear before the committee on an annual basis. So with that, I'm sorry, go ahead.
Just looking back into 2016, which was a year with record M&A activity generally, there's one important observation which we would like to keep as background for you. If you just compare the M&A flows between China and the Western world into both directions, you see that the outbound foreign direct investment of Chinese acquirers really outplaced and outweighs the M&A streams which are going into the other direction. So just adding up what has been invested by Chinese acquirers into Western Europe and North America, you'll see that you basically land at approximately 140 billion USD on an announced deal activity basis. Whereas, as you can see from the slide, the M&A flows going into China were much more limited. This has been taken up by various politicians over the last 12 months, including Germany and Europe, and we'll get to this later on, as an issue of reciprocity, which is a repeating theme in the political process. And against the background of increasing protectionism, is really something which gets into the minds of people looking at this matter. It also constitutes, since this reciprocity issue is being put forward, it also constitutes a shift from the traditional focus on national security up to other more economic factors, which are coming into play on the current discussions, and we'll need to see with the outlooks we'll be making later on whether that reciprocity topic will actually make it into the law at some point. It is not, if you look at the regimes in Europe and the US, but we wanted to alert you that this is becoming a recurring theme in the discussion, that at some point we might see policymakers to consider that more seriously. So with that in mind, on the next slide, you just see the relationship between the PRC outbound investments against other G7 countries and their deal activity outbound. And there again, you can really see how China is picking up. And Just to take the German market, for example, 2016 constituted the arrival of big-ticket public M&A deals into the German market, and this had immediately attracted the focus of policymakers looking into this and raising especially the reciprocity concerns, which I had just mentioned. So with that as a background, and I think we can skip the next slide just to keep in the flow, we would like to turn to the CFIUS procedure, best practices, interested parties, in order to give you the right framework and context on how this committee operates.
So just to start from the beginning, CFIUS, or the Committee on Foreign Investment in the United States, is led by the Treasury Department, and its mandate is to conduct national security reviews of foreign direct investment into the United States. Its membership is comprised of several categories. The first one are the voting members. These are a series of economic and security agencies that have one vote per agency on the committee. The security agencies are the Department of Defense, the Department of Homeland Security, the Department of Justice, the Department of State, and some would argue the chair of the committee, the Department of Treasury, while also an economic agency, often does act as a security agency. The economic agencies are the USTR, the Department of Commerce, and so on and so forth. In addition to the voting members, there are two non-voting members on the committee: the Director of National Intelligence and the Department of Labor, or more rather technically it's the Secretary of Labor, who is the non-voting ex officio member of the committee. In addition to the voting and the non-voting members, we also have a number of White House observers who are participants in the committee and the CFIUS review process. The result of a CFIUS review can be anywhere from an approval of a transaction without any mitigation conditions, to an approval of a transaction with mitigation conditions, to a formal block by the president. This can happen after closing, and it really is, the number of cases that actually have been formally blocked have been very few. There have been 3, but there have been more cases that have been abandoned when the parties were made aware of the fact that there might be unresolvable national security issues. The way that the committee conducts this analysis to reach a conclusion on whether the transaction can be approved or not, is a risk-based approach, where they look at the threats coming from the foreign source of the investment, the vulnerabilities of the target, and the consequences of putting that threat and vulnerability together to come up with a risk profile for the transaction relative to U.S. national security. And on that basis, they decide if the risk profile is low enough so the transaction can be approved, if the risk profile is low enough that it can be approved, but that it requires mitigation conditions, or if the risk profile is such that the transaction cannot be approved because of national security concerns. It is a joint filing typically, and importantly, it is a voluntary filing. And that is a very important consideration, both in terms of the decision, which more and more has become part of the evaluation of the CFIUS, the CFIUS contingencies on a transaction, on whether it makes sense to go ahead and file, or is, depending on the risk tolerance of the parties, for instance, the parties can come to the conclusion that we can bank on the voluntariness of the process and decide not to file. It's also important to keep in mind that once a decision has been made to file, the actual formal filing can be done on the basis of a signed letter of intent, or any transaction, any documentation that shows the good faith intentions of the parties to proceed with a transaction. We routinely do that on the basis of signed letters of intent, but we also have done filings on the basis of substantially advanced drafts of the purchase documentation. substantially advanced enough to give the government comfort that by expending resources on reviewing the transaction, it's not going to be a waste of time because it really does look that the parties are committed to doing a deal. The last bullet on this page, we have listed a range of industries where we have done CFIUS filings. Some of them, as you can imagine, defense, energy, telecommunications, identity authentication, cybersecurity, are very, very much identified with traditional national security and are routinely subjects of CFIUS filings. But there are other areas that you'll see on this slide where maybe a few years ago were not necessarily readily identified with national security, but they are today. And that we routinely engage in a CFIUS analysis and ultimately a CFIUS filing for a transaction in these sectors. Next slide, please. The timing on the CFIUS process, and we're going to get to that a little bit more when we are talking about current trends, but I think that it's important to keep in mind that right now, what we advise clients routinely is that to expect about 4 months on a full review, a CFIUS review cycle. There are really 4 stages, up to 4 stages in a CFIUS filing. The first one is the pre-filing phase, where the parties prepare the notice substantially in the form that it will be submitted and submitted in draft to the committee. The committee under the regulations has 5 business days to review pre-filings, but I can tell you nowadays it takes on average about 2 to 3 weeks for the pre-filing phase to be completed. During these 2 to 3 weeks, we routinely get comments and questions back from the committee, and we integrate those comments and the responses to those questions into the documentation and then formally submit them as a filing to the government. Once that formal filing is accepted for review, which now takes routinely between 3 to 5 days, about a week. Pretty commonly, it's about a week. Once that filing is accepted for review, it starts a 30 calendar day review process. During those 30 days, you get a letter from the committee advising the parties who is a co-lead agency on the review. And very routinely during those 30 days, you also get rounds of questioning from the committee where you have, in effect, 3 days to respond to those questions unless an extension is granted by the staff chair. At the end of the 30 days, you would get a letter saying that the review has been completed and there are no unresolved national security issues, or you get a notice of investigation. Once the deal goes to investigation on day 31 is day 1 of a 45 calendar day review process. So, from acceptance to the end of the investigation, it's about 75 calendar days. It can be shorter, but most often it is not. And at the end of 45 days, again, you will get a letter saying that there are no unresolved national security issues. That could be without mitigation conditions, or it could be after you've negotiated and signed a mitigation agreement with the government. Or if there are unresolvable national security issues, the case can be recommended for decision by the president. He then has 15 calendar days to announce his decision. Important to keep in mind that in addition to the 44 months time period that we're talking about here, the process is confidential, except that when it gets to the president, he has 15 days to announce his decision. And at that point, if the announcement is made by the president, it will be in the Federal Register and it would be open to the public. So important to keep that in mind.
Which means, by observation, the 4-month period is fairly long if you look at a, for example, public takeover context where you have, at least in Germany, and also in other jurisdictions, a fixed timeline and regime by when the process kind of needs to be completed. It can be overrun by such a regulatory process, but this might then have other consequences under the offer. So in a way, this also speaks for the consideration to approach CFIUS early in the process in order to make sure that you can put as much pre-discussion with them and sounding into the process as possible in order to get some relief on the timeline, which is at the back end of the entire process.
Yeah, I mean, and to this point, and this is one of the points that we're going to talk about in best practices. So maybe if we can go on to there you go. So thanks, Brad. Yeah. So what Tobias is really talking about here is really what we've discussed in the second bullet. It also plays into the timing, but it also plays into the strategy of how you want to deal with a transaction. A point before starting to discuss this, it's bear in mind that it can be up to 4 months. So there are transactions that clear after 30 calendar days once the filing has been accepted for review. And in fact, the statistics that have been released by CFIUS for the latest last year for which statistics were released officially was 2014. And I think that they said that there were about 40% of transactions go to investigation. I can tell you nowadays, you really absolutely should bank on a deal going to investigation unless it is truly a clear-cut case of a deal that will not really present any national security concerns. We do get them cleared in 30 days, but really they are, at least in our practice, over the past year or so, they've been clearly in the minority. But coming to the best practices, due diligence, very critical, very fact intensive. It really helps on two fronts. One of them is the more you can get in the due diligence phase about the information about the buyer, their background, the sources of funding, all the types of issues that CFIUS is going to be looking at on the threat side, as well as on the vulnerability side, the business of the U.S. target that is being acquired, how it relates to the government, how it could relate to national security. The more you can get a grasp of that, it really does two things. One of them is that it helps you really get a more realistic view of what kind of mitigation either you ought to be presenting to the government preemptively or that you should realistically expect would be the outcome of the review. Very important, and in addition to that, is that those mitigation conditions that you're going to be anticipating should really be kept in the back of your mind as you are negotiating the allocation of the mitigation or the CFIUS risk in the transaction documents. I can tell you when I started doing this, 20, 25 years ago, very often the condition precedent that we had in a purchase agreement was that just satisfactory approval of by CFIUS, something really very pointed to that effect. That if you got CFIUS approval, you were golden and you were good to go. Nowadays, we spend a considerable amount of time between the buyers and the sellers allocating the mitigation risk between the parties. And it's very important on the buy side in particular to be able to lay down the parameter of the mitigation conditions that could be a possibility for the client and say, okay, well, which ones can you live with? Which ones can you not live with? And in order to be very explicit in the agreements about if these are the conditions that are triggered, then we want to be able to walk away. Needless to say, the dynamics of that between a negotiated deal and one where you are a bidder amongst many other bidders, some of whom who do not have a CFIUS condition, or some of whom have a CFIUS condition but are going to be readily approved, all of that is going to get impacted and is going to play into this. But it is important to really do the due diligence to have a better and a good grasp of realistically what to expect. Consultation with the committee, as early as possible is something we routinely engage in and we recommend. Very often we request it after we've submitted a pre-filing, just so that the committee has the document in front of them so that the discussions can be meaningful. Also, very often, before actually engaging in a pre-filing, we do presentations to the committee to say, here's a transaction that we are considering. Sometimes it's to just let them know that we do not intend to file because we do not believe it's a covered transaction. And the goal of that is to get as much feedback and questioning as you can from the committee so that you do avoid surprises if there's a questionable transaction, questionable in the sense of whether do you really need to file or not. Depending on the complexity of the transaction, it's not just the lawyer showing up before the committee. Sometimes it is important to engage the right outreach program, both from a PR perspective, from a Hill strategy perspective, from an executive branch perspective, and even potentially as these deals tend to get more complex and possibly more of them are going to be appearing before the White House, even a White House strategy. So it is important to keep a holistic approach to the process. Yes, it is a CFIUS approval process, but it is really an approval from a national security perspective, and there can be different layers of not participation in the process of the committee, but there are different layers of overall process that ought to be considered and addressed in order to maximize the chances of a successful review process. One of the things that is very key, and we've seen, is the committee is going to reach its own conclusions on whether a transaction poses national security concerns or not. But we have found it very helpful to be able to list the reasons why the parties at least do not believe that there are national security concerns. A lot of that gets the benefit of input in the pre-consultation with the committee, because sometimes from the questionings that you get from the committee, you can get a sense of where some of the potential issues and concerns can be. Next slide, please. As I said, the parties that appear before the committee are usually the parties to the notice, which are the foreign person making the acquisition and the U.S. business being acquired or the seller. But very often, as I'm sure you have seen, there are others who bring their views to bear, usually in open forums, but possibly even behind closed doors. And this can be anywhere from competitors. It could be members of Congress that may have different reasons for wanting to express their perspective and views. And it could also be customers and business partners. Customers, predominantly U.S. government customers, but it could also be other customers that can bring their perspective. And you may have seen this, that this is taking more and more. We are seeing these letters, open letters signed by multiple members of Congress to the Secretary of the Treasury, urging the Secretary to investigate a transaction or bringing to their attention some national security concerns that the members of Congress have been made aware of, as I said, very often by competitors. So it's very important to keep that in mind. And that is where, very often a Hill strategy or a PR strategy comes in handy when you have a complex transaction. Next slide, please. Trends and developments. So as I said, the pre-filing stage is taking longer. We're getting more extensive questioning from the committee. I found that to be beneficial in several respects. One of them is that early on, you start getting a sense of the kind of fact-finding or the kind of issues that may ultimately become part of the central theme of the deliberations of the committee, which could also help formulate the narrative as you're formulating the final document that you're going to be submitting to the committee. From a practical perspective, when a filing has been accepted for review, when you get questions from the committee, you have 3 business days to respond to those questions, unless you get an extension on them. And it's not a foregone conclusion that you will be granted an extension. So I have found the questioning in the pre-filing phase often to be helpful, especially if the questions require an extensive amount of research, because then you're not under the constraints of that three-day process, and you can perhaps take a little bit longer to fully develop the themes and the issues and the narrative that you want to put in front of the committee in terms of the responses that you are putting together. The 4-month period that I talked about early on, the front end of it, the pre-filing phase, as I said, has been extended. It does routinely take 2 to 3 weeks, and even the acceptance period takes about a week now. So when you think about it, if you think about it, on average, it takes about a week or 2 weeks to put a filing together. We do have the record, I must say, that we put filings together in a day, but usually it's not done that way. We do prefer to take longer.
We shouldn't say that.
That's right. That's right. But when you start thinking about it, so if you take a week or 2 to put the filing together, then you have 2 to 3 weeks for the pre-filing phase, possibly another week for the acceptance before the 30 days and the 75-day triggers kick in, that starts adding up. And so it is important also to Tobias's point, when you are talking about especially public deals where there are timing considerations that become very relevant, as well as other regulatory reviews. So I can tell you, for instance, very often we try to coordinate the timing of an HSR filing with the pre-filing at least. And we also try to make sure that the stories that are being told, of course, are consistent in both submissions. For target companies that are ITAR registrants, there is potentially a 60-day pre-closing trigger for notification to the State Department. So it's really important to keep all of that in mind and make sure that the coordination and all of that is done in a way where it kind of is consistent and it makes sense from an approach between the date of the signing of the document that triggers the transaction process, if you will, to closing. The other added concern of that, of course, is that if the target company also has security clearances, then you have to engage in discussions with the Cognizant Security Agency for mitigation of the foreign ownership. So there is a time element to that as well that very much plays into the timing of the CFIUS process, in particular the timing where DOD as a member of CFIUS would have to report up to CFIUS about if there are any unresolved national security concerns. So it's very important to keep that timing in mind. The other recent trend that we have noticed is the committee has very openly announced that they are actively looking for non-notified transactions. And despite their tremendous workload, they really are doing that. They are very much looking for non-notified transactions. It could be in the public domain announcement, SEC filings, or it could be competitors that bring it to their attention. So it's important to keep in mind that there is an active engagement by the committee to look for non-notified transactions. And so if you are banking on the voluntariness of the filing, then you got to be able to really come to a well thought out conclusion of, well, if we're going to take a view that this is a transaction that does not need to be notified to the committee, let's assume that the committee will find out about it. And so we need to have a strategy on, what is the narrative once and if the committee reaches out to the parties to see why a notice was not submitted, and also then be ready to turn around and submit a notice as necessary.
What is, I think, important is that from the legal perspective, the joint voluntary statement gives you comfort going forward once you have received clearance, right? And of course, you do have the optionality of, do I go into a filing or do I just say our considerations and assessment were that we don't need to file. But in that case, you will not have the same level of comfort for the transaction to be enforceable and valid on a long-term basis.
Yeah, no, and that's a very good point. I mean, so it's important to keep in mind that the committee does not issue advisory opinions. Even on consultations with the committee on a pre-filing basis, you may get some feedback that could be indicative one way or another, but at the end of the day, it is by no means binding on the committee. The only way to get comfort that you do not have a unresolved national security issue that may be of interest to the U.S. government is actually to formally submit a filing. Even if the deal is structured in a way that it is not a what we call a covered transaction, one that the committee would have jurisdiction to review, the only way to make sure of that is to actually submit the filing and get a letter from them, which they issue within 30 days of acceptance of the filing to say that this is not a covered transaction, and so action has been concluded. I must tell you that we're getting fewer and fewer of those, that even in transactions where there is strong support in the regulations that there is a basis for this not being a covered transaction, the committee routinely accepts it for review and treats it as a covered transaction and does its analysis. But to Tobias's point, once you get that letter, unless there was a material omission or material misstatement, that letter is golden, and it is a green light to proceed from a national security perspective, and it doesn't have an expiration date. So we've had transactions where we got that letter, and 3, 4, 5, 6 months later, the deal closed, but we had the letter, and there was not any material change to the point of where we felt that there's a really need to go back to the government to even ask if there's anything else that we need to do. Next slide, please. Filings are up phenomenally this year. They filed, number 120 was filed last week for the year, which if you take it on a linear basis means that we're on track for a 250 average number of filings for the year. Second half of the year, the number of CFIUS filings tend to accelerate because people shoot for year-end closing. So it is not unreasonable to expect that filings can be as high as 300 for this year. One of the added complications now that we are dealing with is the fact that a lot of the political seats between the staff level and the secretary levels that are in the CFIUS reporting chain remain open. In fact, there's an expectation that the assistant secretary position for Treasury is going to be filled in the month of July, early part of July, and that's going to be very helpful. Some agencies, I understand, already have their chains filled and completed, but a lot of them don't. And that does also, create a level of complication, because if you're putting a complex deal in front of the committee, the political chain is not there right now to be able to give the comfort within the CFIUS hierarchy that a decision is going to be not questioned at a later point in time. Having said all of that, and despite all the rhetoric that we've heard about the Trump administration, there is no doubt that of two things. One is, and I'm not sure why the second bullet is not showing up on this, but maybe it's on the next chart. But the 2 points, one of them is there is great emphasis by this administration about jobs in America and rebuilding of infrastructure. And with that, there has been repeated assurances of an open investment policy into the U.S. Despite the open graveyard that we started this presentation with, I must reiterate that a vast majority of these cases do get approved. And of those, a vast number of them get approved without mitigation conditions. But more than ever before, proper planning, proper contingency planning in particular, a proper realistic view of what is and is not within the realm of the possible is more important than ever. And a broad approach that covers all bases, not just the legal basis of the paper submission to the government, but just a broad approach and a strategy is more important than ever. Next slide, please. There we go. So this is the last part of it that I wanted to, which is the second point. Change is poised to happen. There's a lot of discussion right now around Washington, both by administration and there's a GAO report that is supposed to be coming out fairly soon that was mandated during the latter part of the Obama administration by Congress to the GAO on a report on CFIUS, its range, its membership, its scope, that kind of a thing. There's been several proposals that are very much openly discussed in the media. The one that seems to be taking on steam and is expected to be the one that we're going to see at least sooner than the other ones is the one that is being worked by Senator Cornyn out of Texas. We've been told that it's going to be showing up any time now. So it wouldn't be a surprise if it actually is released to the public before the August recess. But I can tell you that all eyes on the CFIUS bar are on that. I'm waiting to see what that is going to be entailing. What we've listed here is not necessarily related directly to the Cornyn bill, or at least the summaries that we've seen of it, but it's really just a collection of the different kinds of issues that we've seen be discussed by different members of Congress, by the media, by different members of the administration. The very first one, for instance, is something that Senator Schumer has been talking about, which is a legislation that was going to expand and DeLauro that is going to expand the scope of CFIUS beyond national security to also include a net benefits or an economic security test. We've been told, and Senator Cornyn has been pretty adamant that, and as well as Secretary Mnuchin and I believe the Secretary Mattis have all emphasized that the scope of CFIUS, at least the proposal that is going to be coming out on the Cornyn side, is not going to be expanding the scope to economic security. It is going to be pretty much stay with national security, but there are going to be technical fixes. There is going to be an effort to capture access to technology through joint ventures, as well as more. There's discussion about rounds of venture capital funding by foreign participants, in particular in artificial intelligence, machine learning, and computer visions. That's become a big topic. The other big topic is hidden ownership. You get an entity that is registered somewhere, but if you peel the onion, you're going to get all sorts of different ownership interests in the company, and there's an interest in working through that. There is a interest in putting more controls on investments by governments of sensitive countries. The sensitive countries that have been identified so far in the press include Russia, China, North Korea, and Iran. North Korea and Iran are a bit of a surprise, to be honest with you, because I don't think at least in my career, I'm going to see any filings before CFIUS coming from North Korea or Iran. But nevertheless, they are being mentioned as being included in the sensitive countries. And also new membership. There has been discussions about adding the Secretary of Agriculture and Housing and Human Services to the CFIUS process. So these are just a snippet of some of the issues that are being discussed around Washington as parts and parcels of the fix to the CFIUS process. With that.
By contrast, if you look at what's happening in Europe and in Germany, I think you can really see Europe is still a green field against the practice on CFIUS, which has developed over the last 25
Since
years.
1988.
Right? Since 1988. I mean, and from that perspective, I think from looking at the European market from the outset, you need to realize there are national security reviews in Germany, France, and all major jurisdictions in Europe. In a way, it's still a green field because those have only rarely been put into practice. The biggest incident in Germany was, again, the Extron deal, as we heard earlier, which was blocked by President Obama, but which also faced a withdrawal of a clearance certificate by the German Ministry of Economics and Energy. And after the German laws were revised over a couple of times before, the whole area of national security reviews in Germany was silent for a very long time. And as mentioned earlier, with the arrival of public takeovers and large-scale transactions really going to the industrial darlings of Germany, politicians became more aware, and as on the Extron deal, started to utilize what is in the law, but which has not really been put into practice beforehand. What we now see is that on a national level, especially in France and Germany, there are discussions about strengthening the regimes and revising them. But there's also a European initiative, and I think Europe starts to realize that there needs to be some sort of a European approach, which on the very long term might be beneficial to the process because you would then possibly, in several years when the laws come into force, have a one-shop process or kind of a passport regime where you would say, if you have clearances by the European level, that also makes up for the clearance in others. But we will need to see how that will be modelized, and I think it is still far too early to make any definitive predictions. What has happened this year, though, is that there was an initiative by Germany, France, and Italy with the so-called 5 topics letter to the European Commission, claiming that foreign acquisitions should be only accepted if there is reciprocity, and that brings us to the old topic of, do we have a level playing field between the investment countries? And secondly, the proposal was made to grant the ability to block transactions if the acquirer is state-owned. And with that in mind, you really see at the moment, it's very much a discussion where the focus is going away a bit from the national security concern, from the classic, view regulators, especially in the US, take more to a level playing field reciprocity approach. The initiative resulted in an internal working paper by the European Commission, which is not published, but which kind of repeats the themes that abilities should be given to block politically motivated investments into Europe with certain strategic interests which conflict with European public policy. And that is at the moment basically where we stand. When we turn to the next slide, we'll see that we are moving towards a more definitive timeline where, Ken, if you could just turn, yes, where you expect the European Commission to come up with their initial legislative proposal by September 2017. By experience, we all know until the law actually gets to the law books and the legislation, it will usually take a lot of time. And given this is an issue which is at the core of European policy, of economic policy, it might take even longer. Just looking back, the European Takeover Directive took more than 20 years to be put into the law books, and we'll really need to see on what type of discussions the proposals will trigger. Anyway, the European Council last weekend basically supported the initiative, gave it its backing, and we'll need to see what the European Commission will come up with. I think at the core, it will really be, as always in Europe, the division of responsibilities between the member states and the EU. Will there be a European authority which can clear off transactions and give the last word to the member states? All of that remains to be seen, but I think in terms of European policy, this will be the key theme which could potentially also block the legislative efforts when looking at how much power is actually given to the European Commission and to the European legislators. And that is something we will definitely look at and report going forward. So I think that brings us really to the conclusions, which are on the next slides to just wrap it up. And given we've only 10 minutes left, Ken, we should probably also have a look at the incoming questions which you are reviewing, and we are of course happy to respond to those when they come in. Just summarizing it, I mean, the critical sectors and the vulnerable states making investments through their investments, I think they've become fairly clear, and it really depends on jurisdiction by jurisdiction how you look at it. My experience with the US was that, if you put together a semiconductor deal with a Chinese investment, you are pretty high up on the vulnerabilities range. But that also means that you, I think, need to be careful not to underestimate vulnerability risks which could appear in other industries, or just by virtue of proximity between the asset which is being acquired to some kind of state-linked institution. Another learning, especially from the German background is deals which can be effected are not only deals which go right into the US, but which are foreign-to-foreign transactions where you only have relatively small assets in the US, but which kind of trigger the US jurisdiction over the CFIUS process. And just looking back to the transactions of this year, if you take Infineon Cree, for example, Infineon is a German semiconductor company which is quite successful and a strong brand in Germany, which tried to acquire Cree, which is a U.S. asset, which is working, I think, in big data applications. No one in Germany really expected CFIUS to go after this type of deal, and I think that has really led to a shift in awareness, certainly in the German market, but also in the European market more generally, as to the risk CFIUS as a committee can pose to a transaction where 2 or 3 years ago, before Philips Lumileds, you probably would have seen this is going to be a no issue, right, and a no-brainer.
Right. I mean, just to keep in mind that Wolfspeed, the division of Cree that was being acquired, is particularly sensitive from many respects. I think from my perspective, some closing observations before we go to questions really is we are very excited about this global national security initiative, and it's because I can tell you last year on 2 transactions, yes, CFIUS was very important, but on one of them we ended up doing a national security review or a foreign direct investment review in Romania. On several of them, we ended up doing ones in Canada, and we ended up doing one in France. So this is becoming of a significant issue in cross-border deals where various jurisdictions have an equity or an interest in the transaction because the target business is either from that jurisdiction or has enough of a stake in that jurisdiction that would be of interest to the government of that particular country. It is an important consideration, and we do spend the time to make sure that we do capture and properly analyze the risk associated with which jurisdictions need to be notified, which do not, whether it's really the buyer's risk, whether it's both parties' risk, and how that does play out. So that has been an exciting thing, and I think as a national security, as a CFIUS lawyer for my whole career, I can tell you that as these laws evolve, they're not going to ease up. that is just the way that these regulations evolve over time, and I think that it is going to become more of a global perspective that needs to be considered, not only just a U.S. perspective.
Yeah. That's a fantastic closing statement, actually. Maybe just the last point is, don't forget how the processes can interact with transactional dynamics. Yeah, on the vulnerability and threat test. I mean, what is in many scenarios, or what used to be unusual, is to really do a bit of due diligence, whether you are doing an auction or whether you are a target company. I think now with these processes in mind and the way the regulators look at the ownership structures, at the financing structures, in order to see who is behind the actual investment, this becomes really a topic. Right. Yeah, and it's also a topic for. It's also becoming a topic for target companies when you are in the public takeover context, where of course the target realizes that it does play a role in that process. Of course, it does. I think by statute, it does have to support the process. Yeah, but there are many varying ways of doing that, right. And I think many target boards have identified this as a potential bargaining chip in order to come to the best results of a transaction agreement.
As you can see, if you let Tobias and I go, we can talk about this all day. But I know that we are running out of time, and I just want to see if there are any questions that we need to address.
All right. Thank you, gentlemen. We did get a few questions asking if there are specific industries or sectors that seem to be subject to more attention or are trending in getting more scrutiny.
The one that obviously jumps out related to IT. So it's semiconductors because of the technological advantage of the U.S., but it's also cybersecurity. It's also any industry where the U.S. business has access to PII, personal identifier information, that becomes quite sensitive, and also core backbone critical infrastructure, financial back offices, energy, all of those are getting a good bit of attention from the government. We've done quite a bit in biometrics and identity authentication over the past couple of years. So really, the way that I would look at it is to say, as you move away from the traditional defense, which is a foregone conclusion, it's going to be, top of the line, top of the list, more rather, in national security concerns, and energy and telecom, really the IT space at large in terms of, the whole cycle for development of semiconductors from, starting from the wafer and as you go through the whole process, depending on the types of chips that we're talking about, but also cybersecurity, PII, also proximity to sensitive installations. But that does not really apply, for the most part. So far, it has applied really within the context of predominantly Chinese deals into the U.S. market.
Yeah. From the German-European perspective, there's much less experience on which type of industries really attract the scrutiny of the regulator. What you do observe in Europe, and that's a typical pattern, is that the transactions always hit the news once a outside buyer looks into the industrial darlings of Europe, right? Often enough, they don't actually raise national security concerns, but concerns about employment and layoffs and all these types of issues. And given there were so few transactions being put under a heavy review, it is very difficult to make any predictions as to the European and the German market. Although I would sign up, I think generally when it comes to security reviews, to the statements you made and the topics which you brought up as examples. And I think the European regulators will look at this and kind of see what the US are doing in order to identify technologies they will put under more intense scrutiny.
Well, we are running right up against the end of our scheduled hour. I hope you found this information useful, and I'd like to point out that additional analysis and commentary is available on our website at whitecase.com/insights. Do make sure to click the View All link on that page to see the many different papers on offer. You'll see we have some here that relate specifically to this topic. You'll find these and many others. If you have additional comments or questions, you can feel free to contact Tobias or Farhad. We have put their contact information on the screen. Gentlemen, thank you so much for sharing your outlooks and recommendations with us. And that concludes our session.